Strategic chokepoints and post-conflict reconstruction in the Strait of Hormuz, legal and economic frameworks. Executive summary. The Strait of Hormuz is one of the world's most critical maritime chokepoints, and any proposal to secure it through military or political intervention must consider multiple legal and economic regimes. International law strongly protects freedom of navigation in straits and state sovereignty, while post-conflict reconstruction efforts rely on frameworks for foreign investment and economic development. Policy and academic debates about such proposals weigh security benefits, e.g. stable trade flows, reduced conflict risk, improved investment climate, against serious risks, e.g. legal and legitimacy issues, regional escalation. Moral hazards, governance pitfalls, uncertain sustainability. The sections below provide a neutral analysis of these frameworks and arguments. 1. The Strait of Hormuz as a strategic chokepoint. Geostrategic and economic significance. The Strait of Hormuz, between Iran and Oman, is a narrow waterway, 21 nautical miles at its narrowest, linking the Persian Gulf with the Gulf of Oman and the Arabian Sea. It is a lifeline for global energy markets. Roughly 20 million barrels of oil per day, about 20% of the world's petroleum liquids consumption, pass through Hormuz in peacetime. In addition, about one-fifth of the world's LNG exports, mainly from Qatar, transit this strait. Few alternatives exist. Disruptions at Hormuz can create severe supply bottlenecks, lengthen shipping routes, and drive up world energy prices. EIA. Example. In early 2026, a hypothetical conflict led to a partial closure of the Strait of Hormuz, which severely disrupted global shipping and caused oil and gas prices to skyrocket. This scenario illustrates the major trade stability concerns if a key choke point is threatened. +1. Security context. Because of this high strategic value, global powers and regional actors are acutely interested in maintaining freedom of navigation in Hormuz. Tensions between Iran and its neighbors or the U.S. and its allies have often centered on the strait, with Iran periodically threatening to restrict traffic in response to conflicts or sanctions. The international community generally views sustained access to such chokepoints as vital for energy security and global trade stability. Ensuring that shipping lanes remain open during crises is therefore a frequent focus of military and diplomatic strategies. +1. Contextual example. In recent years, Iran has considered imposing toll or permit systems for vessels transiting Hormuz, proposals widely rejected by other states, who insist the waterway must remain free to international traffic. This underscores the common interest in keeping strategic waterways open and the resistance to unilateral control of such routes. +1. Hypothetical scenario. Proposals have occasionally been floated, often in theoretical debates, for extraordinary measures to secure the Strait of Hormuz and spur post-conflict development in the region. These might include establishing a foreign military base and special economic/commercial zone, possibly through leasing or controlling territory on either side of the strait. It is important to stress that such proposals remain speculative and face substantial legal, political, and ethical hurdles. Below, we outline the relevant legal and economic frameworks and the arguments for and against these types of measures in a neutral, analytical manner. 2. International legal frameworks and principles. Any plan to alter control of territory or navigation rights in the Hormuz region would engage multiple international legal regimes. Key legal frameworks and their core principles relevant to this scenario include legal framework/principle key provisions and relevance. Law of the Sea and Transit Passage. The 1982 United Nations Convention on the Law of the Sea, UNCLOS, guarantees freedom of navigation through straits used for international navigation. Vessels and aircraft of all nations enjoy the right of transit passage through straits, like Hormuz, connecting two parts of the high seas or exclusive economic zones. +1. Coastal, littoral states, Iran and Oman, in this case, must not hamper innocent or transit passage of ships, except under very limited conditions related to security or environmental safety. First D. In practice, even though Iran has not ratified UNCLOS, these transit rights are widely recognized as customary international law. First D. Efforts to monopolize or restrict passage, e.g. imposing tolls or shutting the strait, raise legal objections and often require multinational diplomatic or UN intervention. The Hill. +1. State sovereignty and use of force. Sovereign territorial integrity is a bedrock of international law under the UN Charter. Article 2(4) of the Charter prohibits the threat or use of force against the territorial integrity or political independence of any state. This means that forcible seizure or annexation of territory, even strategic areas, is illegal without proper justification, such as self-defense or explicit UN Security Council authorization. First D. +1. UN Security Council mandates are generally required for any lawful international operation to secure a strait or territory by force. First D. +1. Even then, such operations are typically temporary and limited to restoring peace, rather than permanent control or sovereignty changes. Occupation law under ICHL. If foreign forces do take control of territory during conflict, international humanitarian law, ICHL, e.g. Hague Regulations of 1907, Fourth Geneva Convention of 1949, deems them an occupying power. The law. Occupation is strictly defined as effective control without sovereign title. The law. And under ICHL, an occupier does not gain sovereignty. Occupation is considered a temporary status. The law. Occupying powers have specific legal duties. They must restore and ensure public order and safety, protect civilians, respect existing local laws, unless necessary for security, and provide humanitarian care, food, medical supplies, etc. to the population. The law. +1. Alteration of local governance or exploitation of resources for the occupier's benefit is heavily constrained by law. This means a forceful takeover of areas near the Strait of Hormuz, if it occurred, would legally bind the occupier to act as a caretaker rather than an owner. Basing rights and territorial leases. Foreign military bases are ordinarily established by consent of the host nation through treaties or status of forces agreements. Long-term cession or sale of sovereign territory is rare and politically sensitive, e.g. historical cases like Guantanamo Bay's perpetual lease or the 19th century Alaska Purchase. In modern practice, basing agreements preserve host state sovereignty even if foreign forces operate there. For example, Oman's Duqm Port is being developed as a key facility available to the U.S. Navy under a bilateral defense agreement, but Oman retains sovereignty and control while granting base access and joint use to the U.S. Why? Any proposal to purchase or permanently control Omani or Iranian territory for a base or commercial enclave without full local consent would conflict with these norms and likely be seen as a violation of sovereignty/self-determination. Self-determination of peoples. Modern international law upholds the right of peoples to self-determination, meaning populations have the right to decide their political status and governance. Forcibly removing territory from a state or imposing a new regime without the people's consent would violate this principle. Even in post-conflict reconstruction, legitimacy requires local involvement. For instance, UN Security Council Resolution 1483/2003, which framed post-war arrangements in Iraq, explicitly stresses the right of the Iraqi people to freely determine their own political future. State. Any international administration or economic initiative must ultimately empower local governance rather than supplant it to maintain legitimacy. Sanctions and post-conflict transition sanctions regimes, e.g. those often applied to Iran, are governed by international or national law, e.g. UN Security Council sanctions or unilateral sanctions by individual states. In a conflict or post-conflict scenario, the lifting or easing of sanctions is often critical for recovery. For example, UNSCR 1483 ended 13 years of Iraq sanctions in 2003 to kickstart Iraq's recovery and economic transformation and reintegrate it into global markets. State. +1. Thus, a transition plan would likely involve legal steps to remove or adjust sanctions on the post-conflict country, e.g. Iran, to facilitate humanitarian aid, trade, and foreign investment. Note, there is no single comprehensive reconstruction law, treaty, and international law. Rather, post-conflict reconstruction efforts operate under a mosaic of these legal frameworks: UN Security Council mandates, peace treaties, and international humanitarian/human rights law, all of which aim to balance stability, sovereignty, and human security. 3. Economic and reconstruction frameworks for post-conflict development. If a major conflict or regime change were to occur around the Strait of Hormuz, as a hypothetical scenario, and a post-conflict reconstruction phase ensued, a range of economic policy tools and international support mechanisms would come into play. Common economic frameworks and mechanisms discussed in policy and academic debates include economic mechanism or framework role in post-conflict reconstruction and investment. Special economic zones, SEZs. SEZs are geographically delineated areas within a country where special regulatory, tax, and trade regimes apply, often more free market-oriented than the national economy. Restoration of special economic zones in Ukraine. Focus on reindustrialization and structural transformation of the economy in times of war and post-war period Pitarakiva economy of industry. SEZs are a proven tool for attracting foreign direct investment, FDI, and jump-starting economic activity in targeted regions by offering incentives such as tax breaks, simplified customs, and modern infrastructure. Restoration of special economic zones in Ukraine. Focus on reindustrialization and structural transformation of the economy in times of war and post-war period Pitarakiva economy of industry. In a post-conflict context, establishing an SEZ or commercial hub, for example, near a strategic port or island, might be proposed to fast-track economic development and foreign investment while the broader national economy recovers. Success requires stability, clear legal authority, and alignment with local development goals. FDI protections and legal certainty post-conflict countries often strengthen legal protections for foreign investors to rebuild confidence. This can include bilateral investment treaties, BITs, or accession to international agreements like the ICSID Convention, International Center for Settlement of Investment Disputes, which allow investors to arbitrate disputes. BITs typically guarantee non-discriminatory treatment, national or most favored nation treatment, protect against expropriation without compensation, and allow free transfer of profits. Trade. +1. Establishing a clear investment code, enforcing contracts, and protecting property rights are seen as vital to encourage long-term FDI in a previously unstable region. Reconstruction finance and aid. Large-scale reconstruction is usually financed through a combination of international aid, loans, and grants. Multilateral development banks, MDBs, like the World Bank, Asian Infrastructure Investment Bank, etc., and international financial institutions often provide post-conflict loans, development grants, and technical assistance. State. Donor conferences may pledge funds for rebuilding infrastructure and institutions. In addition, debt relief or restructuring of the conflict-affected nation's sovereign debt is often necessary to restore solvency and reduce sovereign risk. Princeton. Ensuring transparency and coordinating donor efforts, possibly via a UN mandate or peace-building commission, can improve effectiveness and oversight. State. +1. Public-private partnerships, PPPs, where private firms partner with government or transitional authorities to build and operate infrastructure and services, are frequently used in post-conflict settings to leverage private sector expertise and capital. They can help rebuild roads, ports, power, and housing when public funds or capacity are limited. However, successful PPPs require strong legal frameworks and governance to allocate risks properly and ensure the public interest is protected over profit motives. Capital market development. Rebuilding a war-torn economy often involves reviving or creating financial markets to mobilize domestic and international capital for businesses and infrastructure. Establishing a stock exchange or financial center, as suggested in the example scenario, can, in theory, channel reconstruction investments and encourage private capital formation for local firms. This requires re-establishing banking and financial regulations, stable currency and monetary policy, and robust oversight to gain investor trust. In practice, capital markets thrive only under stability and rule of law. Thus, any special financial zone would need a high degree of security and credible regulation to be effective. Example: Oman's own development projects provide a relevant comparison. The Special Economic Zone at Duqm, Oman, outside the Persian Gulf, was established to diversify the economy. It spans 2,000 square kilometers and offers modern port facilities, low taxes, and foreign ownership rights. Oman's cooperation with the U.S. and others at Port of Duqm, including allowing U.S. naval access by agreement, demonstrates how mutually agreed basing and economic arrangements can align with international rules while benefiting local development. This contrasts with any non-consensual seizure approach, highlighting why voluntary partnerships are the norm for bases and trade hubs in sovereign territory. Why? 4. Proponents versus critics' perspectives. In policy discussions about interventions to secure strategic regions or implement large-scale reconstruction plans, analysts and stakeholders express divergent views. Below is a balanced outline of key arguments often raised by proponents in favor of such proposals and critics who caution against them. These are framed as analytical perspectives, not endorsements. Key consideration: proponents' perspective, potential benefits emphasized; critics' perspective, risks and counterarguments. Maritime security and global energy. A strong foreign-led security presence, e.g. military base at Hormuz, would deter threats to shipping and ensure round-the-clock protection of critical sea lanes, guarding against closure of the strait by any hostile actor. This is seen as crucial to stabilizing energy markets and preventing global economic shocks caused by supply disruptions. EIA. +1. A secure base could also combat piracy, terrorism, or illicit trafficking in the region, yielding broader security benefits for all trading nations. Escalation risks. Detractors warn that introducing a major foreign military base or seizing territory could provoke regional escalation, triggering conflict with the state in question or its allies. What is presented as defensive might be viewed as aggression or neocolonialism, fueling anti-Western sentiment or insurgency rather than stability. They caution that additional military buildup could polarize the region and intensify rivalries, as seen when external bases in Oman and Yemen raised tensions with Iran and others. Why? Trade stability and chokepoint control. By physically securing a chokepoint like the Strait of Hormuz and guaranteeing open transit, proponents argue the plan would provide long-term trade stability. Uninterrupted oil and gas flows benefit the global economy by averting price spikes, supply shortages, and costly shipping diversions. EIA. A stable maritime corridor also lowers insurance and transport costs for commercial shippers. In essence, a fortified Hormuz could become a permanent safe zone for international commerce, much like historic international free ports or canals. Economic disruption and legal uncertainty. Critics note that any conflict or forced takeover itself would severely disrupt trade in the short term, exactly the outcome to be avoided. War in the Strait Zone could drive up insurance premiums and deter ships from the Gulf, causing economic shock before any benefits materialize. The Hill. +1. Moreover, if the legal status of a new international zone is disputed, e.g. not universally recognized, shipping companies and investors might hesitate to rely on it, fearing future legal challenges or blockades. Post-conflict reconstruction and investment advocates believe that a secure, well-administered special economic zone, possibly on an island or coastal strip, could serve as a nucleus for post-war economic recovery. By providing a safe environment with robust rule of law and modern infrastructure, it could absorb foreign direct investment and the Iranian diaspora's capital, generating jobs and growth while the rest of the country rebuilds. A stock exchange or financial center in a stable enclave might jumpstart capital market activity and attract international companies to invest in the region's future. The U.S. or international oversight is seen as a temporary trusteeship, offering credibility and expertise until local capacity grows. Governance and legitimacy challenges. Skeptics question whether a foreign-run zone would truly benefit the local population and integrate with national development. Local governance capacity might be undermined if foreigners take over key functions, leading to dependency and resentment. A mismatch in priorities could occur if external administrators favor foreign investor interests over local needs, reviving memories of colonial-era enclaves. Critics stress that legitimate governance cannot be externally imposed indefinitely. Durable recovery requires empowering domestic institutions. Foreign-led reconstruction efforts have been criticized for creating aid/development bubbles that distort the local economy, e.g., high salaries for expatriates, enclave prosperity amid broader poverty. Princeton. +1. Investor incentives versus moral hazard. Proponents argue that strong international backing, e.g. security guarantees, political risk insurance, MIGA, and legal protections via treaties, would incentivize investors to commit capital despite recent conflict. By mitigating sovereign risk, the plan could unlock significant private investment for reconstruction and modernization. Investors could view the stabilized zone as a safe haven for doing business in an otherwise risky region. Restoration of special economic zones in Ukraine. Focus on reindustrialization and structural transformation of the economy in times of war and post-war period. Pitarakiva economy of industry. Moral hazard and investor confidence. Critics counter that heavy external guarantees might create moral hazard. Local elites or factions could rely on foreign intervention instead of compromising, or might engage in reckless behavior expecting bailouts, prolonging conflicts. Investor confidence remains fragile if the overall country's stability is not assured or if a peace deal is tenuous. Some investors, particularly beyond the extractive industries, will stay away until a nationwide peace and clear legal stability are achieved. Investment Monitor. +1. There's also a risk that early investors may be more like short-term speculators, vulture investors, rather than partners in sustainable development. Investment Monitor. Regional and global spillover effects. A secured Hormuz corridor and vigorous reconstruction could yield positive externalities, reducing the risk of a failed state in Iran, stabilizing a volatile region, and demonstrating international commitment to rebuilding. Proponents contend this could deter other states or non-state actors from exploiting the situation and set the stage for better regional trade integration and cooperation in the long run. The presence of a well-regulated international zone might even encourage neighboring countries to pursue peaceful commerce rather than conflict. Regional blowback. Opponents highlight the potential for negative spillovers. Rival powers, regional or global, might respond with countermoves, e.g. other militarization or proxy conflicts, if they see a permanent Western foothold at their doorstep as a threat. This could widen a conflict beyond initial borders. Additionally, if a new regime or special zone is viewed as imposed, neighbors might refuse to cooperate economically, hampering regional trade and investment. They also warn that if reconstruction benefits are uneven, e.g. concentrated in a special zone, other parts of the country or region might experience jealousy or continued unrest, undermining long-term peace. Key takeaway: both potential upsides and downsides are acknowledged. A heavy foreign role in securing a strategic region could enhance short-term stability and investment, but carries high risks of legal breaches, regional pushback, and unintended consequences. Sustainable success likely requires broad international legitimacy, adherence to legal norms, and strategies that prioritize inclusive, locally led development to avoid the pitfalls highlighted by critics. 5. Constraints, risks, and feasibility considerations. Finally, it is crucial to underscore the practical constraints and risks inherent in proposals to assert control over a region like the Strait of Hormuz without host nation and international consensus. Below are key issues frequently identified in neutral analyses. These overlap with some of the critic perspectives above. Legality and international legitimacy. Acquiring territory by force violates international law and would lack recognition. Any post-conflict arrangement without clear legal basis, like a UN mandate or a valid treaty, risks being seen as illegitimate by the global community and by the local population. Lack of legitimacy can fuel insurgency and deter cooperative investment. Verse D. Regional escalation. A unilateral seizure or militarization of Hormuz could provoke regional conflict. Neighboring countries and great powers with interests in the region may respond aggressively to perceived encroachment, leading to broader militarized disputes. Why? Moral hazard. If external powers signal willingness to forcibly intervene and rebuild, local actors might feel less incentive to negotiate peace or implement reforms, assuming outsiders will ultimately fix the situation. This dynamic can inadvertently prolong conflicts or encourage reckless behavior, undermining peace efforts. Governance and capacity gaps. Reconstructing or managing a conflict-torn region demands enormous institutional capacity. If local governance structures are weak or delegitimized by war, outside intervention may have to fill the vacuum. However, foreign transitional administrations face limits. They lack long-term legitimacy and their policies can be reversed once local sovereignty is restored. Building effective local institutions and rule of law is a slow process that external actors cannot easily rush. Investor confidence and sovereign risk. Political risk remains high until a durable peace and a recognized government are in place. Even with special incentives or insurance, many investors will hesitate to commit funds to a zone born of conflict. Uncertainty about the longevity of an externally established zone or base, and concerns about potential future legal disputes could restrict serious investment to only the most risk-tolerant players. Investment Monitor. +1. Long-term sustainability. Without buy-in from local society and regional support, an enclave of stability may not be sustainable. A development strategy dominated by an external power can lead to distortions, as noted with past donor-driven reconstruction efforts. Once wartime urgency fades, continued funding and political commitment by foreign sponsors may wane, leaving the project's future in doubt. True stability requires integrating the zone's growth with the host nation's broader recovery and eventually transitioning to self-governance, a complex task with no guarantee of success. Princeton. 6. Conclusion. In sum, the Strait of Hormuz scenario exemplifies a wider tension in global policy debates, balancing the imperative to secure vital trade routes and foster post-conflict recovery with the duty to uphold international law and respect sovereignty. The legal regimes of maritime law and state sovereignty set strict limits on intervention, while economic rebuilding hinges on investor confidence and inclusive development. Policymakers considering extreme measures, such as establishing foreign-run bases or zones, must navigate a web of legal conditions and ensure broad legitimacy and local cooperation. Academic and strategic analyses highlight that any short-term gains in security or economic stability must be weighed against the long-term risks of regional backlash, dependency, and legal breaches. Ultimately, sustainable success in post-conflict reconstruction and strategic chokepoint security tends to require multilateral approaches, transparent international frameworks, e.g. UN mandates, consent-based agreements, and a commitment to empowering local governance, rather than circumventing it, to achieve enduring stability and prosperity. State. +1.